Thaddeus Pope is a professor at Mitchell Hamlin School of Law. He's also the director of the Health Law Institute. Professor Pope has been published over 130 times and co-authored the definitive treatise, The Right to Die, The Law of End-of-Life Decision-Making. Professor Pope will be presenting on the legal history of medical aid in dying. Please join me in welcoming Professor Pope.
Good morning. All right, so legal history of medical aid in dying, physician-assisted death in U.S. courts and legislatures. So thanks for having me. Thanks for inviting me to participate in this event. I haven't been in New Mexico since 2008 when I was invited to come and talk about medical futility, which is sort of the opposite issue. It's when patients want to prolong their lives even when their clinicians think that that is medically or ethically inappropriate, but it's a pleasure to be back. So my job that I was given is to provide context and landscape. So I'm not going to really provide any legal arguments, no policy arguments, just legal history. So the objective in the Morris case basically was to clarify the legality of medical aid in dying in New Mexico. And so what I'm going to answer are these questions, which is who else has tried to clarify the legality of medical aid in dying? Where did they try to do that, and how did they try to do that? So here's my roadmap. First, I want to talk briefly about assisted suicide criminal statutes and about the right to refuse treatment. But then I want to move to the heart of my presentation, which is to discuss the paths to the legalization of medical aid in dying. And I'm going to give you 7. So there are statutory approaches, right, either through ballot initiatives or through legislation. There are litigation approaches, asserting claims under the federal Constitution or under the state Constitution, or making statutory interpretation arguments. And then there are some other approaches, limiting prosecutorial discretion and jury nullification. So I'm not going to cover all the law related to medical aid in dying, only affirmative efforts to permit it. And I want to acknowledge that the next speaker, I'm going to talk about a lot of cases now, but the next speaker it actually brought many of those cases, so I'm going to have to be careful and exercise some humility here. Okay, criminal-assisted suicide. And I think we're here in a law school, and I think this is an appropriate place to start, not just because we're in a law school, it's a logical place to start. Across the United States, since the 1800s, assisting someone to commit a suicide is a crime. As Justice Scalia observed, assisted suicide prohibitions are deeply rooted in our nation's legal history. Also here in New Mexico, right? So where the penal code provides, assisting suicide consists of aiding another in the taking of his or her own life, and that is a 4th-degree felony. So this is clearly perceived and may actually be an obstacle to medical aid in dying, these criminal-assisted suicide statutes. And also, and this is where I want to go now, they were also perceived to be an obstacle to even the traditional right to die. So the right to die. This is a foundation, a legal foundation for a right to medical aid in dying. During the 1950s and the 1960s, we invented a lot of medical technology, like mechanical ventilators, dialysis, feeding tubes, right? We were able to keep people alive in states where we previously were not able to keep them alive. And soon enough, the question arose, can we turn this stuff off? Can we stop this? And that question was most famously answered in 1976 by the Supreme Court of New Jersey in the Quinlan case, and they answered, yes, you can turn this off if that's what you want. And during the rest of the 1970s and into the 1980s, more than 100 other appellate courts across the country held the same thing. You can refuse this treatment. You can refuse treatment even if it's life-sustaining or life-prolonging. And that most famously, again, reached eventually the US Supreme Court in 1990, which kind of, well, we'll hear from constitutional law scholars later, but kind of sort of held that there may be a right, even under the US Constitution, to refuse life-sustaining treatment. So in New Mexico, this was codified actually pretty early on, as early as 1977 in the Right to Die Act, and then that was updated later in the Uniform Health Care Decisions Act. But there was a concern, even then, at that time, that turning off this life-sustaining treatment might constitute assisted suicide, which we know is a crime in New Mexico. So there's still this sort of chill, right, from the assisted suicide criminal statute. And so to deal with that, in the Uniform Health Care Decisions Act, the legislature specifically defined that the death resulting from the withholding, withdrawing of health care is not assisted suicide, just to clarify that it isn't going to constitute a crime. We don't have that kind of clarity and certainty when it comes to medical aid in dying. So if medical aid in dying does constitute assisted suicide, and if assisted suicide is a felony, then medical aid in dying is a felony. So that's enough of the background. Now I want to move on to the pathways to legalization. Pathway number one, litigation under the US Constitution. So claims have been inserted under the Due Process Clause, the Equal Protection Clause, and under the First Amendment. A lot of the early cases, in not just Michigan, but in a number of states, were brought by Jack Kevorkian, generally unsuccessfully. But most famously was a case that came out of Washington State in '94, asserting a due process right, and like the Morris case, was comprised of both physician and patient plaintiffs. While they succeeded in the lower courts and in the Ninth Circuit, ultimately unsuccessful before the US Supreme Court. And then at the same time, pretty much almost chronologically parallel to the case coming out of Washington, was a case that came out of New York, asserting that the criminalization of medical aid in dying violated the Equal Protection Clause. And again, successful before the lower federal courts, the Second Circuit, but not before the US Supreme Court. I did a little math, and I counted up at least 15 appellate judges who found that there was a right to medical aid in dying under the US Constitution. But that math really doesn't matter because, of course, in 1997, the US Supreme Court said there's not a right under the US Constitution. It doesn't violate constitutional rights to criminalize medical aid in dying. However, there have been federal constitutional rights recognized in other countries. So Canada, most recently, recognized this. There were a number of earlier cases. In 1993, Sir Rodriguez asserted a constitutional right in Canada. That was rejected. In 2010, Jim Wakeford asserted a constitutional right in Canada. That was rejected. But in February 2015, the Supreme Court of Canada in the Carter case said, yes, Canadians do have a constitutional right to medical aid in dying. They actually held the effect of that opinion in abeyance for 16 months to give the federal parliament a chance to implement that holding. And they did, and now in almost, these are just some stats, but in every single province in Canada, medical aid in dying is now being offered and used. It's actually now being attacked. There's multiple constitutional challenges to the law because the law that the Parliament enacted is more restrictive than the scope of rights that the Supreme Court of Canada held that patients have. Also, in Colombia, the Supreme Court of Colombia held a constitutional right to medical aid in dying. Again, wasn't implemented until, or wasn't used until it was implemented by Department of Health regulations in 2015, but now patients are getting medical aid in dying in Colombia. So not everybody went the opposite way of the United States. South Africa, like the United States, held that there was not a constitutional right to medical aid in dying. And similarly, in New Zealand, recently held no constitutional right to medical aid in dying. Interestingly, the plaintiffs in all these cases were lawyers. The patient plaintiffs in all those cases were. So let me go back to the United States, right? If we don't have a federal constitutional right, since we don't, the focus really has turned to the state level. So the next two pathways are enacting state statutes. And the two ways to do that are through ballot initiatives or through traditional legislation. In terms of ballot initiatives, around half the states, all the blue states here, have a popular referendum or ballot initiative process. And that's been used for this purpose. Some of the early efforts in the late 80s, early 90s were not successful. And that's because actually what those initiatives were trying to do is legalize both medical aid in dying and euthanasia. And the distinction is this: medical aid in dying requires self-ingestion. In other words, the patient has to take the final overt act herself, while in euthanasia, the physician is going to take the final overt act and inject the medication into the patient's veins. So the most notable ballot initiative, as we already heard from Dr. Morris, was the Oregon initiative in 1994. It got caught up in litigation for several years and didn't really get off and running until 1998. And as Dr. Morris noted, it's not just that they enacted it, it's that they had a very thorough and careful data collection process. And so we know how many patients got the prescriptions, how many patients ingested the prescriptions, who are these patients demographically, and why did they ask for the prescriptions. So we have a very thorough, well-documented track record, and the track record shows, as Dr. Morris observed, has a high patient safety, unblemished patient safety record. And based on that record, the state of Washington had a ballot initiative in 2008, basically copying the Oregon statute. And then most recently, last year, Colorado, a ballot initiative, also a virtual copy of the Oregon statute. And there have been other ballot initiatives, and they've been really, really close. Massachusetts and Maine, 49-51. And it looks like we are going to have a ballot initiative in South Dakota. They're collecting the signatures now. It looks like they're going to meet the target. So it'll be on the 2018 ballot in South Dakota. Other states have taken a legislative approach. So again, all these statutes look exactly like the Oregon statute. Vermont enacted in 2013, California in 2015, and then Washington, D.C. just this year. So we've now enacted 6 statutes, 3 through ballot initiatives, 3 through legislation. We have 6 states with statutes representing about 20% of the U.S. population. Other countries have also taken this approach to legalizing medical aid in dying. Notably, the Northern Territory in Australia, which claims, and they have this claim, the first operative assisted suicide law in the world. Because even though that postdates Oregon's ballot initiative, remember Oregon had an injunction, so they didn't get off and going until 98. So this was in effect in 95. But it was repealed, it was short-lived, it was repealed in 97 by the federal Australian Parliament. As the name suggests, Northern Territory, it's a territory and not a state, and therefore the federal Australian Parliament has the ability to override their domestic laws. That's significant because that's what's happening right now with Washington, D.C. Washington, D.C. also not a state, and similarly as in Australia, Congress can override the domestic, the home rule laws of the District of Columbia, and they're doing it right now. The bill's already passed the House, and now it's in the Senate. And that's notable because we've actually been moving in one direction, which is expanding end-of-life liberty. We've never actually retreated to constrict end-of-life liberty. If Congress overrules the DC law, it would be the first time we've gone backwards. Quebec also enacted a statute, this is before the Supreme Court of Canada ruled, enacted a statute just for that province. And we have additional and ongoing efforts to enact statutes legalizing medical aid in dying. This year, 2017, more than 25 states had bills to legalize medical aid in dying, including, of course, here in New Mexico, you had bills both in the House and the Senate to do that. It is worth noting, in fact, this year, some of the bills, at least in Hawaii and Maine, advanced pretty far, passing at least one chamber of those state legislatures. And there's a hearing on Tuesday in Massachusetts. So pathway number 4, right? Federal Constitution, state statutes, litigation under the state constitution. There have been at least 15 cases asserting claims under that criminalizing medical aid in dying violates the state constitution in states from coast to coast, as you see. Unfortunately, none of those have had any lasting success. Some have won at the trial court only to lose on appeal. There's 3 cases of that. Of course, one is here in New Mexico where the trial court held there was a constitutional right, but the appellate courts did not. Similarly, in Florida, a Palm Beach court found it violated the Florida Constitution, but the Florida Supreme Court did not agree. In Montana, and I'm going to come back to Montana in a minute, but in Montana, the state trial court held that there were rights under the Montana Constitution to medical aid in dying. That one wasn't reversed by the Supreme Court of Montana. It was vacated by the Supreme Court of Montana because the Supreme Court of Montana found that there was no statutory prohibition to medical aid in dying, and therefore they did not need to reach the constitutional questions. More typically in these cases, there's just been losses straight at the trial court and appellate court levels. At least 10 examples of that, unfortunately. The earliest case, and it's actually weird that this case gets cited a lot as precedent in current cases, is not even technically a medical aid in dying case. This guy, Tom Donaldson, was a mathematician, and he had a brain tumor, right? And it was really nothing to do about the brain tumor. It was growing and growing. So what he wanted to do was to freeze himself, to cryogenically preserve himself, and then he would be thawed or, I think the word is reanimated, at a later point in time when we knew how to deal with the brain tumor, right? And of course this would cause his death to cryogenically freeze yourself, so the court interpreted this as seeking a right to assisted suicide and said no right under the California Constitution to that. Similarly, in Colorado, no constitutional right in Colorado, no constitutional right in Alaska. Most recently, 2 more cases in California, citing Donaldson, both in Northern and Southern California, no right under the California Constitution, no right under the California Constitution. Cases rejected in Tennessee, and just a few days ago in New York, no right under the New York Constitution. So not a great track record in terms of state constitutional rights. No appellate courts have held that criminalizing medical aid in dying violates state constitutional rights, although 3 trial courts have. There are a number of active cases still ongoing, so we'll see how those turn out. There's a case that's now going up on appeal in Hawaii. There's a case proceeding in Massachusetts, just got past the defendant's motions to dismiss, the trial court level. And there was a case that was going to be brought, a lot of discussion about this in Iowa, wasn't. But the bigger point is this is a symptom that people are discussing it and they are innovating additional cases. Pathway number 5, litigation under state statute. And basically the idea here is, the argument is that assisted suicide is very different from medical aid in dying, that medical aid in dying literally does not fall within the scope of the prohibition of the assisted suicide statute. And in fact, of course, they are very different, right? So if you think of the movie It's a Wonderful Life and you have the main character who just lost the money from the Bedford Savings and Loan, he's going to jump off the bridge, right? That's sort of paradigmatic suicide, right? You have a financial loss and that's very different than a terminally ill patient who's going to die soon anyway and just wants to control the precise timing and manner of that death. The courts actually get that, right? They recognize that medical aid in dying is different than traditional paradigmatic suicide. Nevertheless, consistently hold that it's still legally, it's still assisted suicide. So this argument hasn't worked out too well. The first case brought by Ms. Tucker was in Connecticut, unsuccessfully, and then it's been included, including in the Morris case in New Mexico, it's been included as an additional argument in all the state constitutional law cases that have been brought, but unfortunately never been accepted. It's worth noting this same argument has been tried in other countries. So in New Zealand, for example, again, the argument is this is very different than assisted suicide, which is in the statute, therefore it's not covered by that criminal statute. As in all the United States cases, in the Seals case, I tried to get pictures of cats too. In this New Zealand case, also rejected. Again, it definitely is within the scope of the statute. That said, of course, just let me go back to Montana, because Montana did find that the statutes did not criminalize medical aid in dying, although I don't think that's really because they said that medical aid in dying is not assisted suicide. Instead, it's because Montana has a consent defense to assisted suicide, and that would be triggered in the medical aid in dying context, and it wouldn't violate public policy. So it is a statutory argument, but not the same sort of statutory argument that was tried in other states. So in terms of this track record, assisted suicide statute not applying to medical aid in dying, if we want to count Montana, then we have at least one appellate court holding that way. Pathway number 6, limiting prosecutorial discretion. So here, this is different than the other ones, because now we're not decriminalizing medical aid in dying, we're just providing guidance on how you can engage in it without getting penalized, but it still is a crime. This actually was the approach for decades in the Netherlands before they enacted a statute. Basically, we just had an understanding that there were certain conditions under which it could be provided. It's still the way things work in Switzerland, where, in fact, Switzerland is the medical aid in dying tourism destination of the world, but it has no law affirmatively legalizing the practice. The most significant case in terms of this approach would be from the UK, where Debbie Purdy took a case up to the House of Lords. It was actually the very last case that the House of Lords heard before it became the UK Supreme Court. And what she argued was, look, you got to provide more guidance and transparency. She asserted a right under the European Convention of Human Rights. It violates our rights to not be transparent as to when you're going to prosecute this stuff. And the court agreed and directed the Crown Prosecution Service to issue guidelines and guidance as to when they would prosecute. They've done that, and it's public, it's on their website, and they have listed a bunch of factors as to when they will or will not prosecute somebody for engaging in conduct that would contravene the assisted suicide law. And in fact, those guidelines have provided enough comfort that people are comfortable enough, legally comfortable enough, to assist in this way, which is to accompany patients from the UK to Switzerland and have medical aid in dying in Switzerland. But they haven't provided enough legal comfort that physicians in the UK, on UK soil, will provide medical aid in dying. Closer to where we are here in New Mexico, just across the border in Arizona, in Bisbee, Arizona, they kind of took this approach. And the city enacted a resolution urging prosecutorial discretion by the county attorney to deprioritize cases where what would otherwise be an assisted suicide is a case where the patient was terminally ill and had intolerable suffering. Pathway number 7, jury nullification. Again, we're not decriminalizing medical aid in dying, but we're basically, again, sort of providing de facto immunity. The most famous case of this is a case by Dr. Quill. So Tim Quill took one of the cases to the U.S. Supreme Court in '97. Earlier, before that, he published a case about his own practice of medical aid in dying in the New England Journal of Medicine, and then was prosecuted for that. But the grand jury refused to indict him. So the most famous case, also pretty famous and visible, where time after time after time after time, they could not convict Jack Kevorkian, even though very, very obviously and transparently he violated the relevant statutes, but the juries would not convict him. So let me just conclude. Am I doing okay on the? Let me make sure I'm on. So I've given you 7 pathways to legalizing medical aid in dying. I want to just quickly set aside 3 of those. First, the idea of prosecutorial discretion and jury nullification are nice to think about, but I don't think sufficient to give physicians like Dr. Morris enough comfort, because there's not enough predictability and certainty as to your legal prospects. Similarly, I want to set aside the U.S. constitutional right, because the court has already ruled 9-0 that there is no constitutional right. So let me just give you the quick sum up on the other 4. So in terms of ballot initiatives, we've enacted 3 statutes through ballot initiatives. We've enacted 3 statutes through legislation. And we have 1 court holding that the assisted suicide statute doesn't apply to medical aid in dying, and still no courts holding that the criminalization of medical aid in dying violates a state constitution. Thank you. So I was told to save time for questions, and I apparently have succeeded. So, is there a mic? So the law review students have mics, and I guess they will come to you if you raise your hand. There's somebody kind of in the middle.
Here you go, sir.
Oh, there you go.
Thank you. Could you speak a little bit more about how the unraveling of the D.C. Decision constitutionally or by the feds what's the mechanism of how that would be unraveled or could unravel the D.C. decision?
Here's what happened. When DC passes, in 1973 they got home rule. Right before that, they weren't even an autonomous lawmaking entity. But even with the home rule, whenever they pass, the city council passes something like the medical aid in dying statute, Congress has 30 or 60 days, depending on the nature of the legislation, to, I think it's called, pass a resolution of disapproval or something like that. They didn't do that. In fact, it's very hard to do that because within that time means it has to pass both houses and get signed by the president. But they didn't do that. They tried, but weren't able to make the deadline to overrule the statute. What they're doing now is it's just a budget process, right? So it's in the overall budget for DC, and they just are defunding this and a bunch of other things that at least the relevant congressional committee doesn't like. I think there's an abortion provision also that the DC City Council passed that they're defunding. So they're basically making it such that the DC city government cannot implement, right? It mandated to this DC Department of Health to get this going and to issue guidelines and to issue the forms and paperwork in the same way that it works in the other 6 states. But this basically would prohibit the DC government from moving forward. Thank you. And so it passed the House. This is in an omnibus spending bill, right? It passed the House, and we'll see what happens now. Yeah.
So in terms of New Mexico, since we don't have direct referendum, the closest it seems to me we have are constitutional amendments to the New Mexico Constitution, which of course has to pass the House and Senate, and then it goes to the next general election ballot. As you broke out the referendum, some, I assume, were authorizing that state's legislature to pass statutes similar to what has been offered here, and I assume others were also amending state constitutions to create that right that was sought in the Morris case. Could you comment on that?
Well, if I understood your question right, I don't believe that any of the referendum were to amend anybody's state constitution, right? So like in Colorado and Oregon and Washington, those just became statutes. None of those actually Colorado initially, one of the earlier drafts was to amend the Colorado Constitution. And I'm not an expert on that, but I'm just using my intuition to think that it's going to be harder to amend the Constitution than it is to enact a statute, even through the ballot referendum process. But that isn't what anybody did. So nobody has amended a state constitution to assert a state constitutional right. Yeah, and now that you said it, I guess I could have put up pathway number 8, which is ballot initiative not to enact the statute, but ballot initiative to amend the state constitution. And why would you do that? Well, I mean, there are reasons why that would have benefits compared to just enacting a statute. Of course, as we learned from the experience in Oregon, there were efforts to take out that. It was enacted through ballot initiative 94. There was another ballot initiative that the legislature put it on the ballot, right? It wasn't even a popular initiative, to undo it, to repeal it. And there have been efforts in other states to undo, as we saw in DC, for example, to undo it. So that would be one reason to put it into the Constitution. So that, yeah, I don't know that I've read about, it's something worth thinking about. Thank you.
I wonder if you could comment.
You have a mic.
Oh, I'm sorry. I wonder if you could comment on the court ruling about Final Exit Network in Minnesota.
So, and I didn't check before I got up here, but I think either just a couple days ago or maybe early next week, we'll know if the U.S. Supreme Court's going to take cert on that. So, what this case is about is very different than everything we're talking about. We're talking, as we started with a physician, we're talking about a practice where a licensed healthcare professional is assisting somebody to hasten their death. Final Exit Network, takes a very different approach. They advise, so it's a non-medicalized approach to hastening death. And what they do is they advise you on how you can hasten your death on your own as a layperson. And one of their methods, or popular methods, and this is what the case in Minnesota was about, is they tell you how to put a hood over your head and then fill it with an inert gas like helium. They don't help you do that. They don't buy the helium for you. They don't buy the hood for you. They don't put it on for you. So all they're doing is giving you information, okay? They were prosecuted and convicted in the state of Minnesota. The claim that, well, they lost before the Supreme Court of Minnesota, and the claim that they're bringing to the U.S. Supreme Court is to say that violates our First Amendment right of speech, because all it is information. We're just telling them how to do something. So it's not assistance. Right, so what they call final exit guides are, maybe if the person wants them to be there, yeah, so they may also be there. So right, that's a fact question, which is, if it is pure speech, then they might have a good First Amendment claim, but what they do might go beyond speech, and therefore that's going to weaken the scope of their First Amendment claim. But you're right. In fact, in the case, there's also allegations that they held, so the person tried to take the hood off, that they held her hands down, right? If that's true, then of course that obviously goes beyond speech. That's material, physical conduct. There's a couple over.
I actually got two questions. One is the resistance to a legislative fix. Has anybody looked at, maybe they have, maybe one of the problems being a person's religious beliefs? Does that have to do a lot with the resistance? And the second one I got sounds like a crazy question, because I don't really know about this area, but when I keep thinking about I'm not sure what they call it, argument or the law in the area of a person's right over their body, and you can go to a doctor to abort a fetus. Is that much different than, I mean, why isn't it the right over your body, or that argument not been made? Or is that just a wholly different kind of argument? You have a right to control your body, so why isn't that helps with that constitutional fix?
I didn't quite catch the phrase that you said. You said, why isn't this like what?
Well, I'm wondering how is it you can have the right over your body to control your body, and I'm talking about aborting a fetus, and you get to go to a doctor to help you do that, right? And if you have a right to control your body, why don't you have a right to control whether you die or not?
Right.
You're
So
controlling
this
your
is,
body.
this is where we are. And I don't think it's philosophically sound, logically sound, ethically sound, but legally, we have this really well-grained distinction, what we might call the active-passive distinction, right? Where in terms of a negative liberty interest, the right to refuse any intervention in your body, right? So I don't want this. No, that's well established, right? So physicians cannot do stuff to you. Nobody really can do stuff to your body if you don't want them to do that. And at least legally, we think that that's well settled. But what's not settled legally is an affirmative right. So now what you want is the introduction of a new thing, right? It's affirmative, the introduction of secobarbital or whatever the lethal medication is going to be. And that's different because now we're not talking about a passive refusal right. You're talking about an affirmative, active hastening of death right. And that's just a sharp distinction that is really well, I don't think it's rational, but it's really well ingrained in the law.
Now, twice now you've used hastening of death. My understanding of New Mexico law at this point, and it's in the optional advanced healthcare directive, is that we can direct doctors to give us pain-relieving medication even if it hastens our death, but not if it terminates our life. And words are really important for attorneys. So you seem to be equating hastening death with termination of life, and I don't believe New Mexico law does that. I think New Mexico law says we can get medication that hastens our death, but not if the doctor's assisting us in terminating our life. Can you comment on that?
So we have, first, New Mexico, like every other state, is guilty of having adopted a lot of legal fictions to help, whether those were politically necessary or whatever. But let's put that one aside. If you want, we can talk about that. But let's just say that every single day, right, or right over here across the street at this hospital, right, people are making decisions to turn off ventilators, to stop dialysis, right? We know that that will lead relatively quickly and necessarily to their death, right? So therefore, the physician and the patient are making a decision that is going to cause the patient's death, even though they could have stayed on dialysis indefinitely for years and years and years. So that's why I say that is hastening death, right? You've made a decision to have your death, you've taken conduct that's going to cause your death way sooner than it would have happened but for that conduct. In the case of the case you're talking about, that is different. Okay, so now if we're talking about pain medication, right? So now let's just say morphine, that's what people usually talk about. So then we are introducing a new lethal agent. To go back to the previous question. So it's not passive, now it's active. We're introducing a new agent. And it may hasten the patient's death. But we've adopted, and this goes all the way back to Thomas Aquinas, and it's ingrained in the law as well, the doctrine of double effect, that's okay, because the intent of the physician is not to cause the patient's death, it's to treat the patient's pain and suffering. It might cause the patient's death, but that's just a known side effect, not the purpose and intent. And to avoid falling on the wrong side of the law, she would want to document that the reason she's using the dose she's using is because previous doses were inadequate to alleviate the pain and suffering, right? If you jump to a super high dose, then the inference is going to be that, well, you intended to cause the death. But I don't know if I hope I was responsive to your question.
But it's I think that there is a distinction between hastening death and terminating life, and I don't know that you were making that distinction when you were commenting before.
Right. I mean, maybe Dr. Morris could comment on this, not to put you on the spot, but.
No, that's okay. I was like jumping. I think the difference for me, I'll just speak loudly or use this microphone. Thank you. I think the difference for me between the principle of double effect and physician aid in dying is solely who is administering the medication. Is it the doctors or the hospice nurse pushing the drug, or is it the patient taking it? That, to me, honest to God, is the real distinction.
Thank you. Let's all give another round of applause for Professor Pope.